Well, thank you so much for coming out tonight on this finally a spring evening. My name is Lee McGrath. I'm the Executive Director of the Minnesota chapter of the Institute for Justice. I'm also the firm's legislative counsel, so I'm responsible for lobbying on a national basis for all the legislative activities that the firm does. What I'd like to do tonight is talk to you a little bit about the type of public interest litigation and lobbying we do by walking through our 4 pillars that involve property rights, economic liberty, free speech, and defending school choice. Then I'll dive into the one pillar that is perhaps the most difficult to conceptualize. I think people get an idea, understand property rights, especially people in New Brighton understand property rights after Midwest asphalt. But I'll talk about economic liberty and some of the crazy regulations that go on and are enacted at legislatures and why they're enacted at legislatures and how difficult they are to litigate because of some of the New Deal decisions done by the Roosevelt Court that are still with us today, despite lots of evidence that there is no foundation for them. If we have time and we're feeling good, I then like to talk about judicial activism and judicial engagement and how the two are different and why we believe in judicial engagement. And I hope to convince you to have a view different from a traditional conservative skepticism about judges. Please do not wait until the very end to ask questions. Please engage. And April, it's now about 10 after 7, so shall we go to about 7:45, 7:50, and then take a break. If you want to talk some more after that, I'm happy to stick around. So that's the rough outline. How's that sound?
Great.
Okay. So the Institute for Justice, it was founded in 1991. It was headquartered then, as it is now, in Washington, D.C. We've moved across the river to Arlington, Virginia, but that, for all practical purposes, is Washington, D.C. And in the last 10 years, we have opened up state chapters in Arizona, Washington State, Texas, and Minnesota. And Minnesota is a great place for a free market, libertarian, public interest law firm. We have a very low barrier to entry into the political class. We have a clean and competent judiciary. We have lots of media. We have cable access. We have 2 major newspapers. We've got all sorts of television stations and talk radio, and we have Sue Jeffers. And so there's plenty of access for a public interest law firm that likes to engage the public and try to win cases in the court of public opinion. So this really is, and we're in the 8th Circuit, Federal 8th Circuit, which is one of the more friendly, more conservative circuits in the country. So we like being here in Minnesota and have been here since 2005. What do we do at this libertarian public interest law firm? Well, most of our efforts involve suing the government.
Yay!
And so we are in the fortunate position of having about 6,000 donors, and they give us sufficient funds to employ about 60 people across the country and we never have to charge our clients any money. We represent them for free. And the other side of that coin is that we're looking for clients who have issues with the government in our 4 pillars, the things that we litigate. And we're looking for clients who are just as passionate about the constitutional principle at the heart of the litigation that we are. Said differently, we don't like to settle cases. We like to litigate cases to decisions. And we look for cases where we can win for Gina and have it affect everybody in the room, everybody in New Brighton, everybody in Mounds View, everybody in Minnesota, and perhaps beyond on Minnesota. We're looking for cases that have that multiplier effect, that winning for one changes the law so that others are freer. So let me dive into the type of cases and get your reaction to some of these cases. Our most famous case in 20 years at the Institute for Justice is one we lost. We represented Suzette, my colleagues represented Suzette Kelo. Suzette and her neighbors refused to sell their homes in New London, Connecticut to the New London Development Corporation. The Development Corporation decided that it was going to use the powers of eminent domain to force the sale of those homes. The project was not for a road. It was not for a government building like a school or a courthouse. It was not for the remediation of blight. These homes were unblighted, not blighted. It was not for power lines or the transmission. It was for someone else's private development. So the New London Development Corporation wanted to take from A and give to B because B promised higher property taxes and more jobs. Well, we thought this was wrong, but unfortunately, in June of 2005, by a 5-4 decision, the majority of the Supreme Court said that such a taking that a taking for private use was consistent with the Fifth Amendment that says takings must be for public uses.